I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. Thank you, Madam Chair. So sitting here listening, as you all know, I asked the speaker for this committee after the people instructed me to via notices that they provided, drawing attention and making, showing controverting evidence that due process as required by Part 1, Article 15 of the New Hampshire State Constitution is being violated. It's not being provided. Before you take any liberties or rights from people, you must find guilt by a trial by jury. That's in a court of record that moves by common law. Everything else that is being talked about right now is extraneous details. Fact finding is done by juries. Whether the circumstances of a case provide for leniency, that's determined by a jury. So the committee is getting way off track, and to say that family court discussion has to be limited is totally antithetical to the whole point of this committee. It's about due process related to DCYF. And DCYF takes children by bringing a petition to family court where there is no trial by jury and the facts are not found by a jury and it doesn't move under common law and the evidence is picked and choosed as to how it's going to be weighed. Okay, so all of those things are way off track. The first thing that the members of this committee need to understand is you already all swore oath to protect those rights under Part 1, Article 15. You swore already. Now you've been given notice. Now you're receiving it again. You swore. If you break that, you're breaking the contract. Okay, that's maladministration. So that is the main responsibility of this committee, is to ensure that the people are getting trial by jury before think of it. Losing a child is akin to capital punishment. That's something that needs to be dealt with in a trial by jury. You can't take rights, you can't take liberties. You need a trial by jury. The only thing that can change this, maybe Part 1, Article 15 should be read every 5 minutes in this committee, so it keeps your eye on the ball. After hearing at the last meeting the testimony of Andrew Noyes, it laid out very eloquently what is required by the Constitution. So I recommend going back and listening to that, maybe transcribing it and keeping it taped in front of you. I reached out to DCYF via email after the last meeting, and I said, after I heard what I heard today, I can only conclude that what's happening is very unlawful, and please, I'm bringing it to your attention as well. Please make it stop. I asked.
I'm going to extend you to 10 minutes because you're already at 3 minutes. So,
wow. Okay, thank you.
You're welcome.
The legislature used to hear, this is really what's going on, is the people are coming and saying, help. Our rights are being violated. You promised that you would ensure that we have these rights at all times and that you would be at all times accountable to us, and that if there is an abrogation of rights happening, that without delay we would deal with it. And it's been lost throughout history in the way that things have been run in this body, but redress of grievance is our first job in the Constitution. Writing laws is second. And at the beginning of this country, the very first act was to deal with the redress of grievance. And then all the committees that formed were not subject matter committees. They were committees named after the person whose issue had been brought forth. They met. Sometimes they would make special acts just to fix this wrong for this one person. You know, this is completely doable. And you'll get, I don't want to get too far off, but that's really your main job here, is to ensure the constitutional protections of the people. All the other stuff, like a jury of your peers is the best body to determine of whether you've committed a harm that deserves severe punishment or, lesser punishment. Juries find the facts. They're a representative body of the people as well. and that trial by jury is such an integral part of our rights in this country. I mean, the courts of common pleas existed here before the instituting of this form of government, the Republican government. So, I mean, it's carried from the English common law, and the fundamental principles behind the Constitution are the common law. And the Constitution in Part 1, Article 30 says the people, it says a frequent recurrence to the fundamental principles of the Constitution and a constant adherence to justice, moderation, temperance, industry, frugality, and all social virtues are indispensably necessary to preserve the blessings of liberty and good government. That's what the people did with those notices. They pointed us to the fundamental principles, and they're saying, help us now fix this. So for DCYF to have administrative tribunals where they find fact, they're acting as investigator, which is usually executive branch function, right? Law enforcement. Then they're acting as the judge and jury, and they're issuing a penalty in the form of putting you on that registry, which limits your job abilities, volunteer abilities, maybe potentially your custody of your children if you get divorced later. All of that steps into the realm of taking liberties, and it requires a trial by jury. There's a federal case that was already ruled in against the SEC. It's SEC versus Jarkesy, and it's in the Supreme Court now, and it's looking at this too. Congressman Thomas Massie just had a reining in the administrative state kind of committee that is looking at these issues too, and he received notices. And so you take the instructions and you follow what the people are telling you. If they're showing you that their rights that you swore to protect are not being protected, and stay focused on that, and stay focused on what the trust indenture that is the New Hampshire Constitution, that all of the constitutions are, their express trusts. What they say in Part 2 is what is how government is to operate, and Part 1 is reserved back to the people. We're not supposed to drift into any part of Part 1 to mess with it or shortcut it. You have to keep it the way it is. So DCYF, if they get a call, the way I see it, they get a call. They go in. They can ask voluntarily to work with the family and see. We understand there's a problem going on, and the family can voluntarily work with them. But if not, you have to do a sworn affidavit to confer jurisdiction to the court for them to then issue a warrant and then have an investigation. So like you can't even have a warrant without someone making an accusation. And actually in this state, everyone is a mandated reporter. It's not just, that's just a common misconception that it's only certain people and professionals. And I just wanted to throw that out there. It's a side point, but and that also would prevent frivolous and, retaliatory and malicious claims and accusations being filed and then not being held accountable because, filing a false police report or committing perjury in an affidavit, those are crimes. Those can be held accountable too in criminal court. So I just look at, you've got to bring them into a court of record where the magistrate is independent of the cause at hand, meaning they're not getting paid by the same program as who brought the cause forward. They're not a part of the same agency that brought it forward, right? They have to be impartial. The jury is chosen from their peers. All the facts are tested by the jury, and all of this is underpinned and the court is moved by common law in criminal court and in civil court. That's how it's supposed to be. But these statutes have been implemented that sidestep that, and it's all null and void. So it needs to be completely redone and thrown away and fixed. As far as, there's a maxim of law that says prevention is better than cure. There's a lot of people who have already been very severely hurt by these unconstitutional courts, and the state of New Hampshire might be liable in the future for what occurred there if it's true that and I fully believe that it is, that how it's being done is not constitutional. So we got to consider that, and then the very real harms to the families on both sides, because if you have an impartial tribunal that's actually judiciary with a real judge and jury, um, you know, it not only will it be more difficult to for someone's subjective like gatekeeping to let a real harm be gotten away with, but either way, you know what I mean? Like it also will prevent innocent people from being prosecuted.
Thank you. That's been 10 minutes. I do want to read for everybody part first, Article 15. No subject shall be held to answer for any crime or offense until the same is fully and plainly, substantially, and formally described to him, or be compelled to accuse or furnish evidence against himself. Every subject shall have the right to produce all proofs that may be favorable to himself, to meet the witnesses against him face to face, and to be fully heard in his defense by himself and counsel. No subject shall be arrested, imprisoned, despoiled, or deprived of his property, immunities, or privileges, put out of protection of the law, exiled, or deprived of his life, liberty, or his estate, but by the judgment of his peers or the law of the land, provided that in any proceeding to commit a person acquitted of a criminal charge by reason of insanity, due process shall require that clear and convincing evidence that the person is potentially dangerous to himself or to others, and that the person suffers from a mental disorder must be established. Every person held to answer in any other crime or offense punishable by deprivation of liberty shall have the right to counsel at the expense of the state if need is shown. This right he is at liberty to waive, but only if after the matter has been thoroughly explained by the court. So my question to you is, in order to understand if that is being done, is it reasonable to find out the policies and the procedures and the intersection between everybody involved?
I think it's already been presented that the way DCYF is doing things and the way the legislature set things up is incorrect. And so now we're all aware of it. So whatever the policies and procedures are, they're kind of secondary. You just have to move forward and start and just put everything, DCYF needs to get sworn affidavits and bring it to the court. They know how to do that. They've done it. I've read cases where they did that. So
Okay, thank you.
respectfully, I think it's already been presented. I think that all the policies and procedures will have to be redone later in the perspective of keeping in line with this, with Part 1, Article 15, and the rest of the Constitution. And I did just want to make, if I may, Madam Chair, one more.
There's one other question. We'll see
Sure.
if maybe it gets you there. Representative Weber?
Are you aware that every single DCYF case starts in court with a sworn affidavit?
That's good, but why doesn't it stay there and then proceed to a trial by jury? That's where it goes wrong. If that's how it starts, then that's the accuser. And then the person has a right to face that accuser under due process. I think the committee needs to really understand what common law due process is. And common law is just those fundamental principles. They're the maxims of law. As an attorney, I'm sure you're very familiar with them. The established maxims, they're basically the laws of law. And they're what judges use to help guide juries in finding fact and making decisions, as well as the rulings of courts. So that all of that comes together to provide what has been consistently and through custom and usage over time shown to be fair and constitutional due process. So that's what I would say is from there they should be taking charges. You can't be soft on crime and then not, you're on one side being soft on crime by bringing it into a quasi-civil, quasi-criminal venue, right, where they don't get a criminal penalty, and you're kind of stringing them along for a year and a half or however long with all these hearings, and they might get a chance and they go through therapy and they do this and that, but that's all sidestepping. If a parent knows that if they hurt someone that they're going to be criminally charged, that's quite a disincentive. It's quite an incentive to, be doing the right thing. On top of it, so you're soft on crime on one side in those tribunals, and then in the family court and the way it's done, and then on the other side we're saying, well, a lot of kids are left to be harmed. Well, I mean, that's why. It's because the facts aren't being found the constitutional way. The founders were very smart, and this trial by jury, was consistently shown to be like just such a foundational requirement of our form of government and society at the founding and going back to England.
Thank you. Follow up from Representative Weber and then Representative Gregg.
Thank you, and I'm reminding myself that this is not the time to dialogue about my beliefs versus your beliefs because they are very different. But and we will have that discussion in a work session, which is where it's appropriate. My second question to you is, are you aware of the fact that DCYF proceedings are not criminal in nature? They are not held in the criminal court, and they are a different kind of proceeding entirely.
Yes, thank you. They are administrative tribunals, and they are unconstitutional.
Thank you. Representative Gregg.
I'm just curious, and what you posed and are saying is necessary for somebody to be accused or have their children taken away. I guess I'm missing the point where the child's constitutional right comes in as far as being able to be safe and have their own rights. Do the parents' rights and their ability to go to court and have this whole jury trial supersede any danger to the child? Like, because those are a process. You have to pick a jury, you have to get lawyers, like you're talking months or years. So how does that work in protecting kids?
So it's kind of a trick question. The child's rights are being protected when someone puts in a sworn affidavit seeking due process to get a penalty for this child and get this child safe. So if that parent then is arrested because of that evidence in the form of a sworn affidavit, they go to jail, their child goes to the next of kin. If they don't have next of kin, then there's a place for DCYF to come in and get involved. But I mean, that's why we have bail, that's why we have preliminary hearings. There's likely a constitutional way to keep a child safe while the due process is being carried out. But that's why due process also is supposed to be prompt, without delay. You're supposed to have a speedy trial. We have all these protections.
A follow up from Representative Gregg.
Yes, thank you. And by the way, thank you. I forgot to thank you earlier. And thank you for taking our questions and for being here. So in this, hopefully I didn't lose my train of thought. The problem is when you're investigating something, and I don't know if you heard me earlier, that what one person might think is abuse, another person sees as, well, I'm just child rearing. This is my right to knock my kid into next week if they're not behaving or whatever. So there has to be an investigation done. So you wouldn't arrest somebody before an investigation is done. And I think that's what the process is now. How would that work? Because you don't want to just arrest everybody that gets accused without I would think that would be more offensive to their rights of just being arrested when we're trying to do an investigation. So where's that balance on that?
Well, I guess that's a good question, but it's kind of a misunderstanding about how criminal investigations are done. Usually people are arrested when they have preliminary evidence, and that affidavit would provide the jurisdiction for the court to then issue a warrant for that person to be arrested. And then any attempt to, before or during the arrest or after it, interfere with the ability for the investigation to be carried out, that would be problematic for the person who is trying to stop that. And anyway, in the interim, either the parent would be in jail awaiting trial, or they would be out on bail and likely would have preliminary orders from a judge that they weren't allowed to be near that child.
Thank you very much for coming and sharing with us. I hope you stay involved. Thank you. Traditionally,